Now we'll discuss problem number 4. And the very problem is that the defendant called the plaintiff a libelous journalist. Defendant proved that the plaintiff had once convicted for publishing libel. Will the plaintiff will publishing libel, will the plaintiff succeed? And the very answer we derived from the very decision of the leading case, Wackley versus Cook, 1849, and the second one is Lehman versus Latimer of 1877. So, in case of defamation, the test is whether the words would tend to lower the plaintiff in the estimation of the right thinking members of the society generally. So, in the case of Wackley versus Cook in 1849, it was held libelous to publish that a newspaper proprietor is a libelous journalist. It was also decided in the case Lehman versus Latimer in 1877 that if there is gross exaggerations, the plea of justification will fall as to call an editor of a paper a fellow editor when he was once convicted. Thus, in our problem, the plaintiff will succeed. And now we'll go to problem number 5. The defendant cut off a fruit tree, same branches overhanging his land, and appropriated the fruits hanging on those branches. Is the defendant liable to the owner of the tree? And regarding the very answer, we will derive the decision of the case of Nekram versus the Bank of Bengal, 1891. So, the very facts of the problem as have been taken from the case of Nekram versus the Bank of Bengal as it was decided in 1891. So, the very fact in this case, a person looked the branches of fruit trees overhanging his land and appropriated the fruits. It was held that the right to loop the branches did not carry with it the right to pick and appropriate the fruits. He was guilty of conversion and liable to the owner for its value. Therefore, in our problem, the defendant will be liable to the owner of the tree. And now we'll go to the very sixth problem, and that is some persons combine and go to a theater to boo and hoot out an act. Have they committed any tort? And the very answer to this problem we derived from the leading case, Gregory versus Duke of Brunswick, 1843. So the facts of the problem are similar to those in the case of Gregory versus Duke of Brunswick, and the very decision was delivered in 1843. In the said case, the plaintiff, being about to perform as an actor at a theatre, the defendant with other persons maliciously conspired to prevent him from acquiring fame and profit in that performance. They, in pursuance of such conspiracy, had persons to hoot, hiss, groan, and yell at the plaintiff, and thereupon the defendants with other persons hissed and hooted the plaintiff so as to compel him to desist from the performance, and thereby cause the plaintiff to lose his engagement. It was held that a good cause of action was shown. Therefore, in the given problem, the persons have committed the tort of conspiracy. And now we'll go to the next problem, that is the problem number 7. A maliciously tells his wife that B, another lady, is an adulteress, whether A will be liable for defamation, and in that connection we'll discuss the leading case Winnack versus Morgan 1888, and as it was decided by the Queen's bench. In this very instance case, he will not be liable for defamation because publication of defamatory statement is necessary for establishing an action uttering of libel by a husband to his wife about some other lady is no publication on the common law principle that husband and wife are one, as it was decided in the leading case Winnack versus Morgan in 1888 by the Queen's bench. And now we'll go to the next problem, and that is problem number 8. And here the conductor of a bus belonging to a municipal transport corporation, for sake of fun, changed places with the driver and negligently collided with a private carriage. Advise the owner of the private carriage who wants to sue the corporation for damages, and in that connection we would like to discuss some important leading cases relating to this problem. So the very facts of the problem resemble the case those in case of Inder Mohan Rai versus Emperor in 1927. In the case, it was held that an owner of a bus is not liable under Section 6 of the Motor Vehicles Act for the act of his licensed driver in allowing the bus to be driven without his knowledge and consent by a person who is not a licensed driver. And it was similarly in the case of Beard versus London General Omnibus Company 1900, which was decided by the Queen's Bench. It was held that the defendant was not liable as the conductor was not a person authorized to drive. Therefore, in the present problem, the private owner will fail in his suit for damages as it was decided in the very two important leading cases. One is Inder Mohan Roy versus Emperor in 1927, and the second important leading case relating to this problem is Beard versus London General Omnibus Company 1900, and it was decided in the year 1900 by the Queen's Bench.